Okay, I'm going to try this first venture because I've never tried this before, but hopefully this will work and we'll make it to you in Chicago for your viewing pleasure tomorrow. First of all, let me tell you what a great pleasure it is to address you in person, even though I was scheduled to address you by phone. You surely have one of the finest teachers, and I don't say that because he is one of the best legal scholars on jury selection and also just knows juries better than just about anybody I know. I'm going to take you through a few of my basic things that I've learned over my years in jury selection. I'm not going to spend a lot of time on the social science, but I'm going to spend most of my time just addressing, some of the practical aspects of jury selection and things that I do to look at a case. I've very briefly looked at your case things, and I think when I first look at a case, there's a number of things that I look at in specific. First, that is most important, most critical, is to identify the issues in the case. And when I say the issues, it is the issues that you think are most problematic to your case. This is difficult because you're an advocate and you're supposed to find the strengths of your case and sell those strengths to the jury and the judge and even opposing counsel. But for jury selection purposes, it is your job and it's incumbent on you to actually step into opposing counsel's shoes and actually try their case. Because as I'm sure Ted has mentioned many, many times, jury selection is jury deselection. You are trying to identify those high-risk jurors that are most problematic for you in your case and your clients and identify the issues that drive them. Try and get rid of them for either cause or with a peremptory challenge. So, how do you do that? Well, in your specific case, obviously, if you are representing the contractor in this case, you have a number of things that you really need to focus on. If you are taking a look here, you have to look at what are really what I call the decision drivers in the case. In other words, for a jury, what are the things beyond the facts that are going to drive their decision making in the case? The core thing that I think, or the first thing in defending the contractor that you're going to look at is obviously anybody with negative contracting experience. So that is the first core question that I would ask in either a questionnaire or in voir dire, which is who here has had a negative experience with a contractor or with a builder or with a subcontractor or with a plumber or with an electrician? Because all of those become reference points for the jurors, obviously. And tell me about that. So you want to have them talk about their negative experiences about that. Obviously, on the homeowner's side, if you're representing the homeowner in this particular case, one of the problems that you're clearly going to have is people who think that the homeowner really does know best what's going on for their home. And I would probably design a questionnaire question or a voir dire question, but probably a questionnaire question for both sides in this, which is along the lines of who has the best knowledge of what the construction is of a house. One, a contractor who's working on the house, or two, the homeowner. And that will tell you in general really where somebody's leaning initially. And because what you're trying to do is discern where they're going to be leaning, and if they hear initial arguments from either side, how is that going to make them strongly lean in one direction or another? Another core attitude I'd probably try and figure out in this particular case, as I was plumbing the depths of where the bias in particular could be, really has to do with I guess I would ask them personally, do you, when you have a problem in your house, do you fix it yourself? Do you call somebody up, like a plumber or electrician, to have it fixed? That tells me a little bit about reliance. In other words, whether somebody is reliant on the experts. Obviously, from the plaintiff's side, they're saying, I was relying on the expertise of my contractor. Somebody who's relying on the expertise of others obviously is going to be more prone to, obviously, more receptive to their position. So that's just a few things in terms of identifying it. What you really want to do is identify those issues that are most problematic for you and embrace them. Get jurors to really talk to a certain extent about how they hate you, how they hate your case, how they hate your clients. It's a very counterintuitive process, but it is so important. The other counterintuitive thing that you do is once you've identified those issues in the case that really are the decision drivers, is you want to make sure that you have once you've identified the issues, you want to craft those questions in a way that really gets the jurors to talk. Now, again, difficult because in law school, a lot of us are taught, a lot of you are taught to craft close-ended questions, to control the information flow, to limit it, and to be as specific as possible. Now, the art of asking an open-ended question is actually in ambiguity. You want to create a question which is so generalized that the jurors will actually reference their own experiences and their own opinions and will utter those without necessarily much specificity on your part. Specificity really limits cognitive functioning. In other words, it really has them do an intellectual exercise to try and narrow really what they're trying to ask, trying to answer in your question, which is great for a witness, but terrible for a juror. Because you're just trying to access their experience, their beliefs, their overall general feelings about things. So you want to take that question, which is our normal impulse, which is how many of you feel that contractors tend to do a shoddy job and are unreliable when it comes to actually making the repairs they say they're going to make. That's a close-ended question. The open-ended version of that, the cousin of that, really is, what do you think of contractors? What's your general opinion of contractors and the way they construct a house? What do you think about contractors and their honesty? What do you think about their expertise? And then be quiet, because silence is golden in voir dire. Now, silence is golden because, we don't like to be silent. The fact is, a lot of questions that you're asking are actually difficult questions. When you're asking someone about damages, when you're asking somebody in a personal injury case how they feel about a doctor's care or a standard of care, all those are very tough questions for a juror, and we tend to step on their answers and step in and try and help them, when in fact we need to actually just shut up and let them struggle with a difficult question like, in general, what do you think of our healthcare system these days? In general, what do you think about how doctors deal with the pressure of seeing patients and making a living? Those are difficult questions, and you want to leave the jurors time. Now, the other art about asking the open-ended question is never accept just the first answer, because the first answer is sort of the one that a juror really wants to be the most socially appropriate answer. What you want to do after that is you want to say to the juror, tell me more about that. That's interesting. Can you explain that a little more to me? Invite them to give you the second layer. And the second layer is usually where the richness of their responses comes from. Now, let me sidestep a little bit and talk a little bit about sort of questionnaire design, because questionnaire design is actually very important. The fact is, most judges are reluctant to use questionnaires because they're cumbersome, and they don't know how to deal with the logistics of it. Here in Los Angeles, I think we've got the largest court system in the world, and the judges are extremely focused on keeping jurors, since they have to summon, and I think about 500,000 jurors a day, or it's not that much, but it's a huge number of jurors in order to service the vast amount of courthouses throughout our system. And so they want to be able to have, because if they don't use that juror in a day, they lose the juror for a year. So a lot of times, I find it's important in designing a questionnaire and talking to the judge is making sure that the judge knows really what the usefulness of it is.